Welcome back to another episode of Divorce at Altitude. This week, we are talking about child support, and I am joined by my esteemed co host, Amy Goscha. Amy, can you give our listeners just a high level view on child support and what we're going to be getting into today?
Sure. When people come to us and they have children, they say, what is involved with what kind of support am I going to get? There's a confusion between spousal maintenance or alimony and then child support. So we're talking about the child support topic today, which in Colorado, we have a formula and we have a statute, but it's very long, it's very complicated, and there's constantly changes. So we're hoping to explain kind of high level child support and what goes into it so listeners understand today.
Yeah, and the way that I explain it to clients to begin with is that child support is supposed to help pay for kids. I have at the time of this recording, I have a 9 and 7-year-old. We are looking at doing a trip to Disneyland, and my eyes are bulging at the cost of what a trip to Disneyland costs. But there's also just the milk in the fridge, the food on the table, the driving back and forth between various play dates and sporting events and school. And kids just cost money. And how do you determine the amount that kids cost? And then how between Eric and Melanie, our hypothetical divorce clients, how do we figure out the level of support? Amy, for listeners that don't really understand or know, what are the kind of factors, whether it be parenting time and income, what are the kind of high level factors that go into child support and how it's determined?
Yeah. So for me, and I think some other clients, I try to explain, I say, okay, so in Colorado, we have a child support worksheet, and there's various factors that go into it to essentially calculate it. So the first factor that I look at is party's income. So the on the worksheet, you're going to say, okay, what is mom's income, gross income? What is dad's gross income? And then also you're going to look at there's going to be some credit or changes depending on, at least right now, on overnight. So when we're talking about how many overnights in a year does each parent have the child? So if it's an equal parenting time schedule, then each parent is going to have 182.5 nights. So that's another input. Other inputs are who covers the children for health insurance. You get a credit on the child support worksheet for the children's portion of health insurance cost. There are some other, inputs on there such as extraordinary, and we'll get into what goes on the worksheet and what doesn't. But there are some credits that get taken into account. Also, if you have a child from a previous marriage, like a child that's not like a non-joint child, you get a credit for that. Essentially, what the Child Support Commission did is they did research for families all over the nation, but in Colorado to say how much at these different income levels, how much does it cost to raise if you have one child, two children, three children. And so that's where the research is based off of. And then the inputs calculate essentially what the child support amount should be paid from either mom to dad or dad to mom.
So, Amy, with your son, they determine how much it costs to have heat and utilities, the additional electricity, the housing, the extra room or space in your house compared to my son, and then determines a baseline level in terms of the cost with medicine and food and everything that goes in. And then there's a pie drawing exercise and this is not actually, this is what the child support worksheet is based on. And then I think it's an important point because a lot of people are always surprised. It's gross income, so that's before taxes. You determine maintenance before child support. So if Eric is paying Melanie $5,000 a month in alimony or maintenance, then what happens is that Eric's income will be X, but then it will be reduced by the $5,000 per month. And then Melanie's, and we've got episodes on potential income. And there can be, we're not going to get into, there's so many disputes about what Eric's income is and if he's self-employed and if he's getting money from gifts from family or trusts. That is beyond really what we're talking about here. We will have other episodes on that. But then Melanie, whatever her income is or potential income, if she's voluntarily underemployed, then you'll have an addition of $5,000 per month because that's how much she receives in maintenance. But as you said, if Eric has a child from another marriage or another relationship, then he has those costs that are going to be factored in. And really what we're going into is if both parties, I think the easiest example for people to understand is if Eric and Melanie make the same income and they have equal parenting time, then there will be no child support in that circumstance because they both are going to absorb these costs equally on their own and they are on equal financial footing. But as you said, health insurance, there's always going to be one parent, generally speaking, that's going to pay the health insurance. So if the children's portion of that health insurance is $500 a month and Eric pays for it, then Melanie will owe Eric $250 per month in child support. But the numbers are never just the same income, the same everything. And that's where you really get into. But if Eric has Johnny more parenting time, then he's going to have more of those costs, which is where the overnights come in. And Amy, have you ever had a case in which one parent, particularly the dad, is asking for equal parenting time because he's concerned about child support?
Yeah, everyone is concerned and like it's a hard thing because you never want to negotiate parenting time related to child support, but it all is interconnected. So I can understand why a parent is concerned about that. But it can create disputes over parenting time because the overnights are counted on the child support worksheet.
Yeah, and when I give that example, I think people generally I am a divorce lawyer and can be skeptical, but I do believe in people and their intentions, and especially when it comes to their kids. I think that the vast majority of cases, people are just trying to do the best thing for their kids, and they're not really being driven by financials, but it does matter. And there's different examples of it's not necessarily all about overnights. There are exceptions or the ability for a court to deviate from what the guidelines suggest. But Amy, for you mentioned that it's based on a worksheet. Do you see that worksheet applying in $1 million per year income scenario between Eric and Melanie Wolf?
No, because the worksheet, it has a cap.
Yes, Amy, there is a cap. There's a case in intermarriage of Betcher in which the court is provided some guidance on what happens in above the worksheet scenarios. I frequently deal with these in up in the mountains and with people that make a substantial amount of money. And really, what you're looking at is what the children's lifestyle was during the marriage, and if they flew private, if they went to expensive vacations, if they enjoyed a very comfortable, arguably lavish lifestyle, then the child support is going to reflect that. And it can matter for premarital agreements. One thing I'll just as an aside, premarital agreements can never kind of control what happens on child support. We'll talk about modification down the road, but you can't set in a premarital agreement. But there could be something in the premarital agreement that results in a really disproportionate financial exit for Eric and Melanie after the divorce, and child support is going to take that into consideration. But you mentioned that there's a deduction for health insurance. How are childcare costs and who pays for them, as well as the extracurricular or extraordinary medical expenses? How, Amy, are those addressed in the context of child support?
If it's work-related childcare and it's not something that varies, it's always a decision as a lawyer or as a party to say, are we going to put this fixed expense on the child support worksheet and is it going to get paid by the other parent, their portion through the child support worksheet, or is it going to be off of the child support worksheet and are we going to just split it pro rata to income or however the parenting plan or separation agreement defines splitting those expenses. Is it going to be split off the worksheet, or are we going to assign something on the worksheet?
Yeah, and I think people 2 examples. So if there's a child that's going to daycare and that's a fairly consistent preschool, it's $1,000 a month and it's that amount every month. Then the parties have a decision. If they put it on the child support worksheet and Eric pays for it, then that is gonna reduce the amount of child support that he would owe Melanie or result in Melanie owing him, and there's just this reimbursement, and it's baked into the amount that is paid per month. The other option is if it's off the worksheet, so there's not $1,000 amount on that worksheet, which is probably the better scenario when those costs in particular they go up and down. Medical expenses, if a child has diabetes, there's some predictability about how much are you going to hit your deductible every year, but that's going to be in stark contrast to going to the ER. Hopefully they're not going to the ER and having that deductible or that extraordinary cost every time, but when it comes up, then you can have an agreement on if there's maintenance, then usually that results in a 60-40 split. So Eric usually will have 60% of the responsibility. If that childcare is $1,000, then he'll pay the childcare provider $600, and then Melanie will pay $400. And you can have agreements on 50-50, 60-40, 70-30, so that if something comes up, then they, will pay their respective share. And that's what, Amy, you mean by the pro rata share.
Yeah, exactly. Besides inputs, I think, and it's probably in the imputation of income episode, but people should be aware that if you have a child that's 24 months or younger, you cannot what's called assign a parent an income. And we'll get further into that, but that is something that is important. And one question, I'm sure you get this a lot too, Ryan, is people ask, okay, I'm paying my ex spouse or co parent child support. Shouldn't that cover everything? And so I think, people do have confusion about what does child support cover. And I always explain to people, each party has a basic obligation to support their children. And because the incomes are different in these various inputs that we're talking about, that's what it covers to equal the financial playing field for the children in each household. And then there's these other things. So I do think that can be confusing for people.
Yeah, and for sure, the number one dispute, there can be disputes over how many overnights. It actually surprises me, Amy, in terms of I have had disagreements with attorneys about what the number of overnights are that go on the worksheet. And one, we use custody exchange oftentimes, and when you plug it in, it will tell you what the number of overnights in that software. But there can be disagreements about, okay, vacations, or if there's a 60-40 agreement on parenting time, but then they have equal vacations, that can result in some disagreements on the number of overnights. But set that aside. It's all about the incomes. We will frequently litigate what a parent's income is. And like I said, there's not enough time for us to really dive in on all the potential issues involved with income. The same disputes often arise when it comes to maintenance, when we're first determining maintenance. And so you'll have those sorts of disputes. But Amy, can you give a kind of a high level view on income and how child support views income, and what kind of some examples of disputes can come up when it results in differing child support amounts?
Yeah, so we explained how it's based off of gross income, but then the question is, what is a parent's gross income? If a parent is a W-2 employee, it might be a little bit more simple, but there could be a W-2 employee that, works more hours or gets overtime. An example would be if the overtime is not a condition of their employment, then that overtime is not included when you determine child support. Another thing that's confusing is that it's not just your adjusted gross income on your tax return. So if you have a self-employed person, essentially it's gross receipts minus reasonable and necessary business expenses. So then you have to go through and figure out what are the reasonable and necessary business expenses. What you deduct on a tax return might not be exactly considered a reasonable and necessary expense. Categories we look at are personal expenses that are essentially run as business expenses. And so those can be added back in. You also have the issue of maybe a parent was the earner and the other parent stayed home and hasn't worked in a while. If you're getting divorced, one parent's getting back into the workforce, and there's this question of how much time should it take? How much can this person make, and how much time is it going to take them to make that? And so, what income amount should you put potential income on the child support worksheet? One change that happened in 2023 that's related to that is that when you're looking at what we called imputing income, which means trying to figure out what a person's income is who hasn't worked in a while in this scenario, we have some more guidance within the child support guide or statute that says a party needs to be assigned income for at least 32 weeks 2 hours per week for 50 hours for 50 weeks a year. So there is some determination or guidance as to what's considered full time. I'm sure, Ryan, you can think of some more examples, but those are the top of mind that I can think of.
Yeah, the ordinary and necessary expenses on someone that's self-employed, that results in just a lot of disputes because someone can put on their tax return and they'll expense a business expense for their cell phone, and that cell phone will be it's certainly used for the business, but then there's also and so often experts come involved and they'll say 20% and they'll add back 20% of the cell phone bill, and those issues certainly come up. Then there's trust income, there's gift income. So if a party gets money from a trust or they're gifted money, that may not be taxable. It may not even show up on the tax return. It may not count for taxable income, but it can certainly account for child support. I think the takeaway for people is that gross income when it comes to child support is really broad. And it's if you get any money the court is likely going to consider that uh, as income for child support. The bonuses, if your income varies, we're going to have specific kind of episodes and how-to episodes that I've been doing. There can be disputes if a realtor, for example, if Eric Wolf is a realtor and he makes $1 million one year and then $200,000 the next and then $300,000 the following year, could you do a 3-year straight line average? Do you use a weighted average? Do you look at 5 years? There can be a lot of disputes on what people's income is. The other thing before we move on to modification and enforcement of child support is that the extracurricular activities and the some of the private school, we've referenced that before. We talked about it in our decision making. They can really drive child support, and Eric could make, for example, a substantial amount more than Melanie. But if he is paying for ski racing or ice skating or hockey or private school, the money could then go to the child's private school or ski program instead of Melanie. And that Melanie does not realize that during the marriage, but there's a dispute on whether or not that should be included as a deduction, like you said, Amy. And there's some differing case law. It needs to be reasonable, those costs. And it's a matter of whether there's been a history. There's a case in marriage of Laughlin, in marriage of Payon, in terms of if there's been a historical track record of a child going to private school, then that's going to be one thing. If it's now all of a sudden going to be a new thing, and the idea is that Eric, he may say, I don't want to give any money to Melanie. Instead, I want it to go directly to a child. The other kind of things that I'll mention are there are factors that the court can use as a deviation. And that would be, you referenced overtime. If a parent historically earned overtime, then that could be considered. The one thing I've also seen fairly frequently, especially up in the mountains, is that if there's a non-income producing asset, the court can take that into consideration in deviating from the child support worksheet. So the child support worksheet could say X, and the court says, I'm going to either go high or low based on this deviation. And the having a $5 million house or a $10 million house, which we see in the mountains, that is a non-income producing asset. And the court can say, listen, you've got a $10 million house. That is unusual. And I'm going to either impute money because you could have used some of that money to invest and get a return on your investment and generate some income. So the court can deviate in that circumstance. The other circumstance that I'll mention about deviation is that if there is a party that has a lot of daytime parenting time and may not have overnights, then that also can be considered because the court isn't just going to look at just the number of overnights. But child support can be really complex. It can result in a lot of disputes. And the other kind of unfortunate takeaway is that it can't be set in stone. So, Amy, can you talk about modification? And then we'll finally conclude with enforcement. But what do you tell people in terms of you're going through a divorce, Eric and Melanie, and this is how much child support is? And then what's the kind of caveat or explanation you give, Amy, on child support being set in stone for the rest of the children's lives?
That it's not, that essentially at any time a party can show that there's been a 10% increase or decrease in the overall obligation amount, not just 10% increase or decrease in gross income of a parent, that it can be modified. I also tell people though, sometimes it's more expensive to go through the litigation to modify it. So you have to really do a cost benefit analysis when you're looking at modifying child support. And the one thing that I don't think we mentioned is that in Colorado, child support is through age 19 and parenting time is through age 18. And there's this gap where kids go to college and am I paying child support? I'm paying for college tuition. So those issues also come up. But that's just high level. And then there's certain circumstances where if parents mutually agree to change parenting time, and it depends on if one parent had the majority of the time and then they switch it to the other parent having the majority of the time, a parent can then ask for a court to modify it, what's called retroactively to the date of that agreement. Otherwise, child support modification is only from the date that you file a motion.
Yeah, I saw this a lot when I started cutting my teeth in 2010 with family law cases. It I represented a lot of or was involved in a lot of cases where developers or real estate brokers or other people and the Great Recession was resulting in it really impacted real estate in particular. And so these people they had agreed to in the kind of go years of 2006 and 2007, they had agreed to these really high amounts on child support and then they had no income. And so they said, understandably so, saying, I haven't been working for a year. Doesn't child support, it should be modified from when I lost my job. And under 1410-122, that is not how it works. The only exception is if there is a change in the physical care. So if Johnny moves from Eric's house to Melanie's house and there's a disproportionate amount of parenting time, that is the only basis. Otherwise, it is based on when there is a motion that's filed. Amy, I'll ask you about the mechanics of how Eric or Melanie know about that change of circumstances. But what happens is attorneys will sometimes file a motion and just preserve that date. They understand that there's going to be kind of mediation, but 100% agrees that there needs to be a change in circumstances that is substantial and continuing. I remember we hosted a town hall with the judges in the 5th Judicial District right in the height of COVID, and the
Yep.
judges in Eagle and Summit County were saying, we're seeing a ton of motions to modify child support, but we don't know if this is continuing. And indeed, for people that don't remember, there's definitely people were disproportionately impacted. So restaurant servers or restaurant owners that, yes, they had this lull because their restaurants were closed, but a lot of restaurants made a lot more money afterwards. It was just a matter of, is this continuing? And is the kind of test is, does it going to result in that 10%? But Amy, what can you maybe comment a little bit on how do people know after a divorce if there has been a change?
There's usually a provision in the tax or in the separation agreement that says that parties exchange tax returns on a yearly basis, or there might be some language, and this is probably best practice. There should be some language that says if a party is changing jobs, that they provide the new proof of income. And I believe there is more language now in the child support statute that talks about getting financial documentation as well, which it wasn't in there before, but I'm pretty sure it's in there.
Yeah, I think that just realistically, when Johnny comes home and he says, I'm going on all these trips with Eric and is doing these various things, then Melanie has a better idea of like a general idea of how Eric is doing and financially. But yeah, most of the time there's going to be an annual exchange in May, tax seasons in April. If Eric's on the extended basis, then there can be just this general exchange of W-2 or profit and loss or the kind of basic tax documents. Eric or Amy, what happens if Eric gets remarried? Is that a basis for a modification? Melanie's going to say, Eric is found this new person and he married a doctor and she's making all this money. What happens in that circumstance?
The short answer is no, but with everything, it also depends. So, if for instance, the new doctor wife is lowering her new husband's certain obligations, like paying directly certain things like the mortgage or certain bills that when you're looking at a modification, those things are discoverable and possibly could change child support, but not just based off of the fact that you are dating someone new. That person's new finances really have nothing to do in general with a change in circumstance that would warrant a modification.
Indeed, and I think that often comes up. To turn the page on our final subject or topic, Amy, when it comes to child support, is how do you enforce child support? What happens if Eric just stops paying? What are the options for Melanie in terms of enforcing child support?
She can file a motion for contempt, which is holding the other party in contempt of the court order. She can file what's called a verified entry of judgment or have an attorney do that to essentially have a judgment entered against Eric. And then she can move to garnish wages. But she also can reach out to what's called child support enforcement. So this is part of the child support commission every state because it's very important that child support is paid for the best interests of the children. And if you go through child support enforcement, there are measures where they can even take away someone's license. We can, through contempt measures, put someone in jail. The thing I always think about enforcement is the vehicle that I'm asking for the court, is it actually going to solve the problem? You have to think about, okay, how much money is it going to cost to file like a motion for contempt or how much is it going to cost to do a verified entry of judgment? So I have this judgment, but this person's self-employed. Like, how do I know where he or she has money? Am I going to be able to essentially get money from that judgment? So
There can be some really confusing circumstances in which a parent lives out of state, and we won't get into that, but like interest as of this recording, it's fairly onerous in terms of back child support. So it's 12% compounded monthly. Each of those monthly payments is technically supposed to become a judgment. Amy, when you say entry of a judgment, what you're doing is you're wrapping those all up. You get a judgment from the court of, let's say, $50,000, and that's how much he owes in back support. And then what Melanie can do is go garnish his wages, do these various collection efforts, but they often it costs money. Now she could ask for the court to order Eric pay for those expenses. You don't have that with the child support enforcement unit, but there's always this issue there in terms of the cost benefit analysis. If Eric doesn't have the money, or he becomes temporarily unemployed, or he just becomes unemployed, then if she goes and collects, she might prompt him to file a motion to modify. And there's some consequences with that. And you can't just sit on your hands and say, oh, don't worry about it. You don't owe me anything. There's some case law in Remarriage of Johnson and some other cases about laches, this legal concept of you can't really invite someone not to comply with a court order. And you can also just wait too long. I've certainly seen people where they waited like 10 years before actually trying to collect. And there's a fine balance in terms of, if someone's late, then do you go and immediately file a motion for contempt, or do you wait and see how it sorts itself out? But people need to be careful in terms of what they put in writing, or making sure that any sort of agreement to modify, if there's a temporary kind of glitch or something that comes up, then they need to put that in writing. The final point that I'll add is that there can be circumstances in which they can work out an agreement on. I gave the example about Johnny having a soccer tournament in Phoenix, and there can be an agreement about, hey, I'll pay for that. That should be in writing, and it should be a clear record. If you use Talking Parents, Civil Communicator, or Family Wizard, there can be this cost sharing reconciliation. And I guess another point is that in parenting plans or separation agreements, usually there'll be a provision about, if a parent pays for an expense, the process by which they seek reimbursement. They provide an invoice. They'll need to make sure that, obviously, if it's an emergency room visit, the child had to go to the emergency room, presumably. But before signing a child up, then there would be an agreement, or there would need to be notice. I've certainly seen circumstances in which a parent just goes off and just goes on a spending spree, and then they expect the other parent to share in that cost. And the parent will say, listen, I didn't know anything about this, and I didn't agree to this. Those are issues related to child support, making sure that, or trying to ensure that a child goes and sees a medical provider that is in network and that you work with insurance. All of these things are really relevant for child support. We don't have time to go into every single kind of detail, but I think that those circumstances and the ground that we've covered, Amy, thus far, really give an idea of like why child support exists, how it is determined, and just at least gives listeners an idea of the various kind of competing interests when it comes to child support. Because when children are involved, it can be one of the kind of critical issues. Sometimes people can agree to no child support, and you can ask for a deviation, and they may determine it's not worth us fighting over and over about someone's income, and it's fine. I'll just agree to pay for my expenses. And the courts generally are open to that, but they need to have some documentation. They need to make sure that this isn't just a party kind of browbeating or coercing a parent, because the court has an independent obligation to do what's best for the child and to determine child support, because child support can't technically be waived because it's for the child's benefit and it's not for a party. It's for the child. Any other kind of last thoughts, Amy?
Yeah, I think that it's important for tracking the amounts that have been paid or unpaid. So, for instance, that can be done it can be paid through the family court registry, which is a tracking system. So it is clear as to what amounts were paid and when. And then the other thing I would say is on enforcement is usually on what's called the support order. That's the order of the court that says what the child support obligation is. There's a box that you can check that says if a child support payment is late, like 1 or 2 months, then an income assignment just goes right into place. So you can do that. Whereas if a parent is consistently late, you can establish also like a wage assignment. And what that means is that it's child support gets paid and deducted from one parent's paycheck and then is paid directly to the other parent.
Yeah, I'm glad you brought that up. There are logistics, and usually what I will do is will work with my client either in the other attorney to make sure that child support is automatic. So through some sort of bank transfer, the family support registry is nice because it's a clearinghouse where it automatically will debit Eric's account and then credit Melanie's account. There's usually a lag time, but there's a nice record. And then I guess the final point is that there can be disagreements, or one thing that people need to be clear on is if Eric owes Melanie $2,000 a month of child support, for example, but then he goes and pays something, he will just offset or just reduce the amount and say, listen, Melanie, you owe me $500. I'm going to reduce it. That again needs to be in writing and make sure that it's tied up, because it can get really confusing if Melanie later says, I don't agree that $500, I owed you that. There's a lot of disputes, but when people go through the system and provide the kind of thought that is required and apply the law, then we, at the end of the day, come up with an amount, and then that can always be changed. But until next time, Amy, thanks for joining me to discuss child support, and audience, I hope you learned something, and appreciate you joining us here on Divorce at Altitude. Hey everyone, this is Ryan again. Thank you for joining us on Divorce at Altitude. If you found our tips, insight, or discussion helpful, please tell a friend about this podcast. For show notes, additional resources, or links mentioned on today's episode, visit divorceataltitude.com. Follow us on Apple Podcasts, Spotify, or wherever you listen in. Many of our episodes are also posted on YouTube. You can also find Amy and me at kalamaya.law or 970-315-2365. That's KALAMAYA.law.